Hey everyone, welcome back to the channel. Imagine you're in a courtroom. You have seen it in the movies. Witnesses taking the stand, dramatic objections, fiery closing speeches. But here's the thing. In Singapore, civil trials don't quite happen like that. No surprise witnesses, no emotional outbursts, and no gotcha moments. Instead, it's a carefully structured process where everything is mostly written down before the trial even starts. So today, let's break it down step by step. What really happens in a Singapore civil trial? It all begins with a simple formality. The first day of trial starts with the claimant's lawyer standing up and introducing himself. He will also introduce the lawyers representing the other party or other parties, if there's more than one. After that, the judge usually asks whether everyone is ready to proceed. But before we dive into witness testimony, there are some important procedural matters to settle first. Before the trial, both parties would have already submitted their written opening statements, essentially a summary of their arguments and what they aim to prove. So the claimant's lawyer will ask the judge if these statements can be taken as read. And in most cases, the judge will say, yes, let's proceed. Next up, housekeeping matters. No, we are not talking about tidying up the courtroom. We are talking about marking the trial bundles. These are the official documents the court will rely on during the trial, and there are three main types. The agreed bundle is the bundle of all documents that both parties have agreed on, and it will be used during cross-examination. This could include contracts, emails, invoices, photographs, anything relevant to the case. The bundle of affidavits of evidence in chief, also known as AEICs, is also a crucial bundle. Unlike in the movies, witnesses in Singapore civil trials don't tell their stories live and orally in court. Instead, they submit a sworn affidavit before the trial. It's like a written script of their entire testimony, complete with exhibits. Next is the set-down bundle, containing key court documents such as pleadings or possibly pre-trial applications. Once these bundles are marked up by the court, we are ready to begin. But housekeeping doesn't stop there. Lawyers may also take the opportunity to correct minor errors or typos in documents, such as the opening statement. The judge may allow these corrections if they are not substantive changes. Once all these issues are settled, the trial is finally ready to proceed. Now, the moment we've all been waiting for, witness testimony. But here's the twist. Unlike what you see in Hollywood movies, witnesses don't start by telling their story in court. Their full story is already written in their AEICs, Affidavit of Evidence in Chief. The defendant's lawyer will be the first to question the claimant based on what he said in his AEIC. This is called cross-examination. The lawyer will try to poke holes in the claimant's testimony, challenge inconsistencies, and highlight weaknesses. Once the claimant is done, the other witnesses for the claimant will be cross-examined by the defendant's lawyer one by one. Now, after cross-examination, the claimant's own lawyer has a chance to re-examine the claimant or his witnesses. But there's a rule. Re-examination is to allow the party who called the witness, in this case the claimant, to clarify any ambiguities or inconsistencies that may have arisen during cross-examination. No new issues can be introduced or elicited. And while all of this is happening, there's one important rule. Witnesses who haven't testified yet are not allowed in the courtroom. This prevents them from tailoring their evidence to what they hear. Once all the claimant's witnesses have been cross-examined, it's time to switch roles. The claimant's lawyer now cross-examines the defendant, followed by the defendant's witnesses. And just like before, the defendant's lawyer can re-examine and clarify any questions related to the defendant's or his witnesses' cross-examination. But questions must be non-leading and focus on clarifying issues raised during cross-examination. And just like that, the trial ends. But wait, no fiery closing speeches? No. In Singapore, judges don't usually ask for oral closing arguments. Instead, they direct the lawyers for parties to file closing written submissions, legal arguments in document form, within a few weeks. Now, in order to strengthen their closing written submissions, lawyers usually request for transcripts of the trial. They are verbatim transcripts, word-for-word records of what the witnesses said during cross-examination. These transcripts are crucial in highlighting contradictions or inconsistencies in the opposing party's testimony. After the closing written submissions are filed, the judge needs time to go through everything. A few months later, the judge will issue a grounds of decision, a detailed explanation of the judgment. If any party is unhappy with the decision, they can file an appeal to a higher court. And that, my friends, is how a civil trial really happens in Singapore. Thanks for joining me in this video. I'll see you in the next one.